Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book from Intersentia Limited, a publisher that's based in Cambridge and in Antwerp. They are, generally speaking, concentrating very much on European legal matters, and this one's particularly interesting, and I saw the title and thought this is a book we really should look at and review. It's called The Effectiveness and Application of European Union and EEA Law in National Courts, Principles of Consistent Interpretation, and the editor is Christian Franklin. And it's part of the Intersentia Studies on Courts and Judges series which they've published, and I think it's a very interesting book. I've given the title for our book review, A Topical Review at a Time of Massive Upheaval in Europe with Brexit. I'm recording this in the early part of 2019, and we still do not know the full horror of what is going to happen with Brexit. But in the meantime, we got this interesting book, and I did think from a legal point of view it was really quite something. It's a hardback. There it is. You can see the front. There's the spine, and then the back. There's a little bit of blurb. You probably can't see it very well. There's a little bit of blurb there. Now, it's a slightly different style from our normal books, because this is obviously from Intersentia, and what you have is you have the index, of course, at the back, which is useful. Sometimes they have a different way of publishing it. They actually have the information about the editor at the back of the book. Then you've got the index itself, which is page numbering. It's not a big index at all. It's got a small index, in fact. Look, let's see. There is footnoting. You can see on the last page there. The book runs to some 500 odd pages. The front of the book is here. There is the front page, the main front page anyway. Then you've got the blurb about from Intersentia, and you've got a preface. Always read the prefaces because they do actually give some indication. This is from Christian himself, dated August 2018. It gives you some idea of what the purpose is and what's very up to date about this particular book. Then there's a questionnaire from the author. It's intended to provide a framework for and to stimulate national reports on the application and effectiveness of the principle of consistent interpretation under EU and EEA law at national level. Of course, it's very relevant at the moment, and of course you've got a lot of background information from that. Then you get into the book itself. There's a list of, let me just get into that first of all. After the questionnaire itself, you've then got the contents section, which sets out what the book is, and you've got the different countries that are looked at. And again, I think that's very useful. It's done by country. Then we've got the list of cases, and you see they're actually listed by jurisdiction. And then after that, you can see the different ways in which they're published, depending on which country they come from. Then after that, you've got a list of abbreviations, always helpful in this confusing area, frankly, of law. Then a list of contributors. A lot of people involved here. Christian has brought together a lot of people to comment on and produce information for the various chapters. You can see them listed there. Then there's a synthesis, it's called, drawing some lines on the application of the principle of consistent interpretation in national courts. Now, how relevant this is going to be in the long term, I do not know. But in the short term, I think it is relevant. And I think we can always use, even as a persuasive precedent, or from a persuasive point of view in jurisprudence, we can at least see where Europe is going, even if we're not going to be part of it. And just taking another example, here we go. This is the consistent interpretation in France, revealing the duality of the judicial system. See the structure? Then there's a little index for the chapter, and then it develops the theme. And of course, you do have footnoting. And what you've got is you do have numbering for the various headings. All in all, I found it a very interesting book, and it's not an easy book to read. It's a complicated book, as is the case with much to do with European Union law. And I say that as one who I did not study it before I did the bar exams, but I did it as part of my bar module, and so I have at least some idea of what this is about, although it's a little bit out of date even now because things do change, which is why these books are so helpful. So what do we say about the book in this short review? It's an excellent new text from Christian Franklin. It's been published by Intersentia. and arrives at a turning point, I suggest, for Europe as the UK prepares to leave the EU. And the effectiveness and application of EU and EEA law in national courts will strike, I suggest, a particular chord with many practitioners and judges as the debate heats up on the issue of jurisdiction. And of course, as you know, we still don't really know what is going to happen to the UK in the long term in terms of some parts of the jurisdiction. But as the author says, in the current decentralised system of the EU and of the European Economic Area, the EEA, remember the differences here and what could be happening post-Brexit. Obviously, concerning law enforcement, national courts will continue to play a crucial role in securing the effectiveness and application of the law. And they play this role at a time of legal turbulence, whilst the political world remains deadlocked on the UK's European future in either the EU or the European Economic Area. And it's recognised that much legal research has been expounded on how the Court of Justice of the European Union and the European Free Trade Association Court, that's the EFTA Court, have established and developed the key mechanisms for doing so. Now, most of us will hear regularly from the CJEU, that's the Court of Justice, or the older ECJ as it was, but we don't hear very much from the EFTA Court. And of course that, again, may well have more significance for us possibly in the future. I don't know, but it's certainly something we should bear in mind. And of course we're looking here at the principle of consistent interpretation throughout. And therefore we're grateful to Franklin for giving us some sage advice on where we are at present on matters of interpretation. And I do think that's of some help in knowing where we might be going in the future. And yet the principal scope and limits can only be fully understood if one looks to the final outcome of cases at national level, and how national courts charged with the duty of applying the principle actually do so when faced with such issues in practice. Now, adopting an ambitious and consistent approach, the contributors from 14 European states have reviewed the reception of the principle through national case law, focusing in three main areas. That's reception and understanding of the concept, its criteria for application, and its limitations. And that's the basis of the book. And of course the individual contributions are further synthesized and compared in an overarching comparative chapter. Note the words, I've quoted them. You see, they are using some quite interesting words again here. I think you know what it means, but again, it's a little bit flowery, isn't it? But that's the EU for you to a certain extent. Now, that chapter identifies this is looking at the overarching comparative chapter. This one identifies considerable tensions between, quote, the goals of uniform and homogeneous application of the principles and a plurality of different approaches at national level. In other words, they're looking at things in a different way and possibly coming up without having that level of consistency that we're looking for. And that's really what this book is about. And the findings, of course, further touch on a broader range of issues, providing the reader with insights into the cooperative dialogue between Europe and the national courts more generally. And that really is the wider picture that you're getting. So let me conclude by saying this, that we feel that Franklin's book is of great interest to certainly academics, undergraduates, national and EU, EEA and EFTA institutional actors, to use the current expression, in other words, people who are participating in those activities, judges, practitioners, of course, all of those people who are interested in advisor levels or whatever, in gaining a unique insight into the workings of the European Union and the economic area in terms of its law, its culture and its practice. And that, I suggest, should include the bunch of Brexiteers we have here seeking radical change in the United Kingdom. I don't think they will, however, but what I am delighted for with this book is to thank Intersentia and their studies on courts and justice very much for this book, because I think it helps notwithstanding that people do actually have their minds made up as to what they want. The book was published on the 1st of September 2018. Let's just have one last look at it. There's the front and the back. There's the spine as well, you can see. And if I just open it up in the middle, you can see there are some tables and some charts and things. This is from Finland. Perceptions of the Finnish courts approach to doctrines of EU law. So as I said, it's quite deep. There's a lot of information. It depends on what knowledge you have and which countries you are interested in. You can see the footnoting, very extensive. And again, if we run it through again, you can see again, just another page. This is now dealing with Norway. And again, at the EFTA area, you can see the information again there, the paragraph numbering and so forth. Altogether, I'd like to thank Christian Franklin and his team very much indeed for this book. I think it's a first-class effort, and we're very grateful to everybody who's been involved. Thank you very much. Bye-bye.